I'm now going to introduce our next speaker. She's an attorney, Janet Espey of Espey Law Offices. Ms. Espey has practiced in the areas of estate planning, trust law, and probate since her admission to the California State Bar in December 2004. She's a member of the California State Bar's Trust and Estate section. Areas of particular interest include working with clients and their families during life transitions, representing clients with changing mental and physical capacity, and planning for beneficiaries with special needs. Please be aware that Ms. Espey cannot give individuals legal advice at this seminar. And now I would like to welcome Ms. Espey to the podium.
Good afternoon, everyone. Thank you. And thanks to the other speakers. I've really been enjoying this seminar so far. Oh, thank you. All right. Okay, thank you. So I want to talk to you about mental health considerations when navigating end-of-life planning. And I went the wrong way. Sorry. Okay, so what the topics I want to talk about is what is end-of-life planning, giving an idea of what sort of legal topics that covers, basic estate planning documents, requirements, including cognitive requirements for establishing legally effective estate planning documents, alternatives to estate planning documents. This is for planning when you'd like to start having someone help you, but maybe aren't prepared to totally turn over access to assistance. So some of the things you can do for allowing someone to help you, and also, to name beneficiaries without having to do specific estate planning documents. And then what happens when there are no estate planning documents or other arrangements in place? And then mental health considerations and tips for starting the conversation about end-of-life planning. So what is end-of-life planning? A lot of times people think about that as just plain, who's going to get my property when I pass away? Yeah, they think about dying and maybe having someone to handle their affairs and who their beneficiaries might be. It's funny to me sometimes how people, it just doesn't occur to them that there might be some planning involved with aging, where you start to need more help. There's capacity changes that occur that Dr. Duong spoke about in great length. And there's also very sudden changes that can occur in your ability to manage your affairs. That might be a sudden medical condition, or maybe even an accident, something unplanned for, where you have an injury, where you're not able to do things. So Dr. Duong talked about the baseline, and a lot of us have our ways of interacting with the world, maybe what we do and don't understand, how we manage our finances, maybe with help, maybe not. We have people that we go to for advice and do things. The sort of planning that end-of-life planning involves is thinking ahead for, well, what should happen when my baseline changes? If I'm not, if in some way I'm not able to explain what I want, or if I'm not able to actually do my own business for some reason, like pay my own bills or do things like that. Legally, when I'm working with clients on this, in addition to looking at cognitive changes as a part of planning, there's another aspect of it that it's called undue influence, and inability to resist fraud and undue influence. And when I was growing up, we used to call that street smarts. Someone comes up to you with a real fast talking story, and you can kind of, okay, I'm not going to give this person $50, to go over, to take a cab somewhere. But sometimes you don't have cognitive changes, but your ability to kind of filter out, um, what someone's telling you, and your ability to have a little cynicism, or that can really lessen, to where you become vulnerable to that. Um, so the focuses are there's kind of two general areas. One is to plan for managing your finances and assets and business matters. And then the other is naming someone to act on your behalf for medical treatment and things like making decisions about your residence. Um, it's also really important to make any instructions you have regarding medical treatment, and then name beneficiaries for receiving your assets after your death. Um, Often with that sort of planning, you might need to plan for ongoing management for your beneficiaries. If you have children, maybe that are minors, or if you've got a loved one that has a financial situation where it might be benefit to set something in particular up for them. A lot of my clients have loved ones who receive public benefits, or they qualify for public, and there's a lot of planning you can do to leave assets for them that won't interfere with the eligibility for that. So that sort of planning, thinking ahead for the other people in your life, and then ultimately, by doing this in advance, you can make it a lot easier for people to help you and carry out your wishes. And you can also avoid some of the procedures that are in place for when you don't have documents. I'm going to talk about those in a little bit, but you can make it a lot more streamlined and less expensive for the people that are helping. So let's see. Okay. Basic estate planning documents. There are 3 basic documents, and then the 4th is a revocable trust that I'll mention in a minute. But the will is what a lot of people think of when you think of estate planning. You see the movie, maybe someone's in their deathbed and everyone's around, like, put me in the will, or I should be in the will, or whatever. Or you might have the reading of the will, after someone's passed, everyone's there to hear what does the will say. So it's funny. Some people love that idea, and they spend a lot of time, they'll call me, okay, this person's out of the will, and they'll tell me what the wrongdoing that the person did, or they'll say this person's in, and it can be enjoyable for a lot of people to plan that. You also, with your will, name one or more individuals to manage your business. They file your final taxes, they handle paying any bills of yours, and take care of carrying out your wishes. The will, while it does name someone to manage things for you, it really is a document that only goes into effect after you've passed away. So it's just one part of planning. The next document, the durable power of attorney for finances. This is a document where you name an agent to manage your affairs for you. And it can be either immediately effective, it can be very flexible, it can be for a limited purpose, or it can be a general purpose. It's effective only during your lifetime, and the authority under this ends at death. And I like to really stress that, because so often I have people come to me where they're, well, I have this durable power of attorney. They're not letting me into the account. Shouldn't they be letting me into the account? It's like, well, no, they're not allowed to let you into the account, because your authority ends with that. So that's an important piece of things. It's rare nowadays with all the technology we have, but I still occasionally have a client that will say, I'm traveling overseas, I want to name someone to do a particular thing for me while I'm gone. But nowadays people really use this more to plan for changes in their cognition, for when they're not able to manage things for themselves. And then the Advanced Healthcare Directive, this is where you designate one or more people to act as agent for your healthcare. You document instructions regarding your medical care, and it lasts during your lifetime. In California, the person named as your agent is also the one authorized to dispose of your remains, and they can authorize an autopsy. So there is some authority that continues beyond death. And then the revocable trust. This is a document that for the assets that are transferred into it, it's very similar to both the power of attorney document and the will, in that it for the assets that go into it, the document dictates what happens at each phase. What happens when you become incapacitated, who the next successor trustee is. That would be the person managing your assets. And then you describe what happens, when you pass away. And the trust can even continue on, for a period of time where you have sub-trusts, for children or other beneficiaries that continue on. And it's a really great way to plan when you have a lot of instructions or there are concerns about, maybe not wanting to give assets outright to somebody. So California, the revocable trust is a huge tool in California for avoiding probate. Probate is a process that occurs when you pass away, that it occurs in the Superior Court Probate Department, hence the shorthand, people call it probate. But there's a court supervised process where notice is published that you've passed away. There's a space for creditors to come and file claims, and it's all supervised. Your heirs are determined, or if you have a will, it's admitted, and the beneficiaries are confirmed, and then everything's administered and distributed. Having assets in trust will avoid that court process. So one big benefit of the legally effective documents is that they're really intended to be comprehensive. The authority that you grant to the people in the documents, it's a blanket authority. If you can present a valid document, a third party is actually required to accept it at face value, and turn over assets in an account, allow you to, for some reason, changing your channel lineup is like, they think everyone, I don't know, you try to do that for a parent or another elder, somebody, they act like you're trying to break out like all their assets. But you can, sometimes the companies where you're trying to change the accounts, they won't let you do it, till the person authorized, whoever's on the account, that'll let you handle that sort of business. I like to think of it as actually kind of stepping into the person's shoes. So you get to act in place of them to do that. So the third party recognition is very important. And then also really important with the documents is the people named in them. There's a lot of legal protections in place for you when you name somebody in your documents in that capacity. In California, there are multiples of damages. If someone was acting as your agent or your trustee and they took your money, not only do they have to pay you back the money, but they might have to pay you back 2 or 3 times what they took, plus any money they made off of it. And there's also criminal liability, if somebody violates their duties to you. So those documents give you a level of protection. So, okay, let's see. So requirements for establishing legally effective estate planning documents, they are determined by state law. So each state has usually capacity requirements, what they're looking for someone to be competent enough to sign a particular type of document. And then there's also execution requirements. Execution requirements are really based on trying to avoid fraud. It's an area of law where my clients are always disappointed they can't DocuSign. It's actually an area of law where you get the wet signature. If there's a question about whether a will is valid, they might even date test the paper. And it's really interesting the sorts of things they'll do to make sure. They'll study if something's a little off in a copy. Sometimes that's a classic to say, well, we lost the original and then here's the copy. That so the execution requirements are meant to kind of help protect that. So if you're interested in estate planning, it's really important to find out the legal resource or consult an attorney in your state. And if you're working from the internet, be really careful that the forms are state specific. California has a number of forms available for free that are put out in California statute. They give you the language and you fill in the information, and they publish those with all the instructions for properly doing it. That's meant to encourage people that maybe don't want to go to an attorney or can't afford to go to an attorney, to have the basic document. So if you're looking to do something, it's really helpful just to remember the state. Be focused on your particular state, and don't be shy about calling an attorney. I'm always happy to look at people's documents that they've done themselves. I'm very happy to do that. You can buy 15 minutes or a half hour of somebody's time. And it's a good investment. When you do work with an attorney, it's sometimes attorneys and notaries that some of the documents require notarization. There might be some duties and obligations that those professionals have to kind of protect you when you're executing documents. So let's see. Okay. One of the things I just like to mention, because for people, I really enjoy working with my clients that maybe have some maybe atypical cognitive neurodivergent, different situations. And when you do estate planning documents, depending on the type of document that the person is signing, the legal capacity, there's a real push to try to honor somebody's right, to name someone to help them, to have this sort of assistance, and also to be able to name their beneficiaries. That's kind of a basic right that we like to recognize, at least here in California. And the sorts of things, if maybe you have a situation where you rely a lot on somebody to help you, even to help you with decision processes, the capacity to do some of the estate planning documents are a lot more flexible. Oh gosh, 1 minute. Oh, okay. I will. Alternatives to estate planning documents, and I'm hoping we can just put these slides up on the website. Oh, okay, sounds good. So we'll put this up. These are some suggestions for you about kind of estate planning light, how to get someone to kind of start assisting you if you want some help. And okay, let's see. Okay, so mental health considerations and tips for starting the conversation about end-of-life planning. I know this kind of dovetails with one of the questions we had during the break there, but end-of-life planning, it can be very triggering for people. If there's any family disappointment, loss, fear of, just people have a lot of anxiety about the idea of turning things over. It can really make people uncomfortable, and it's especially it's all part of you have your adult life and you're feeling you have your status quo with how you're managing things, and that maybe starts to change. And a lot of people don't think to plan until maybe there's been a crisis or some sort of obvious change, and often it's a loved one that's really pressuring, to say, look, oh, you need to have a power of attorney. Let us have power of attorney, or let us do something. It's this is something where allowing someone over your finances or medical decisions, it is a vulnerability. And I had one really elderly client when I called her to talk about making a change to her document. She didn't recognize me right away, and she was like, well, I'm fine, with my document. Like she had that kind of conditioned in of don't change the documents. Like if someone's, and I was like, oh, A+, but yet, we need to work on this a little, and I kept talking with her. But it is something often people really have worked hard to be to be independent, and it can be frightening to think of that. I think one of the things that's so important when you're approaching someone about offering to help them is to really have the right attitude about it. Getting the authority over someone is really to carry out that person's wishes. It's not the time to make them break up with their partner that you don't like. It's not the time to make them quit smoking, or to do these lifestyle changes. It shocks me sometimes what people think, like, oh, I'm their medical partner, I'm going to block the visitor, at the hospital. That's people can tell if you're wanting to control them, and I think kind of having your mindset right is important. Explaining what will happen if no planning gets done, it can really get taken out of your hands. I didn't really get to go into that, but some of the court involvement where they impose conservatorships, you might have someone appointed that isn't necessarily who you want. Also, with estate planning, you might have somebody named by law as your beneficiary or heir that isn't who you want. So it can be really helpful to know kind of what's going to happen if you don't do anything. You may need to bring up the subject more than once, and I think as professionals, it can be helpful. I sometimes have clients come to me that say, oh, I was there for my checkup and my doctor said, do I have a power of attorney? Yeah, which I love. I often am asking people about their health directive, and they'll say, oh, my doctor had me do one. So it is helpful to kind of just be mindful when asking people or talking to people about their support system. Do they also have these kind of basic things in place? So yeah, I think that's a good stopping point. So thank you. We're sitting down.
All right, we're going to do another Q&A as our speakers go ahead and come up for this topic. And then do we have any questions on the computer yet? Nope. Okay. Any questions in the room? Thank you.
Yes, from what I understand, the executor is supposed to submit the will to the court within 30 days. What if he does not?
Make sure it's turned on. Sorry.
That's
It was on.
okay. So what the rule is first of all, there aren't police executors, and I think a lot of times people don't know their duty about starting the process by presenting the will. And so, and some families even have a period of mourning where they don't do any of that sort of business for a period of time. So if you don't do it within the time period, typically that's okay to pick it up and do it. But the responsible person, who's the executor, becomes liable for any losses that people have for failing to do it. So if you kind of let it go for a long time, and there's maybe I'm trying, someone could have a lawsuit against you if they could try to argue that maybe there were assets that needed to be sold or things that needed to happen. So that's a good question.
Thank you. All right, I'll go ahead and yes, Joy. Yeah, go ahead.
You mentioned about a notary republic, on your. What if you have a close family member who's a notary, allowed to be a notary, but they're out of state? Because I'm in California, but they're on the East Coast. Are you able to use that that person across the country as a notary?
If you travel to New York State or to whatever state that the notary is in, it will be legally effective, but you must sign within the state. So if if I'm notarizing a document in California, I must be a notary in California. And then some states recognize, interestingly, some states allow for virtual notarization, where you can. California does not recognize that, though. So if you, not unless you traveled out of state, you would have to go to the other state. You'd have to physically be there for California law for it to be valid. Oh yeah, no problem. Some states allow that. So I, right off the top of my head, I don't have an example for you, but some, California does not allow that.
Okay, great. I have a question while people think of additional questions to ask. You had mentioned how attorneys, and this is specifically, I'll be asking from the California perspective, how does an attorney test for capacity if you're just meeting someone for the first time?
That is such a good question, and I had a whole if I could talk to all of you as long as I would like, I have a lot to say. It's actually very interesting. It was like Dr. Duong's list of all the cognitive areas. So, obviously, as an attorney, you're not, an expert, but knowing what you're looking for. One of the first things I do is I look at how willing the person is, and if I can, a lot of times I'll meet with them alone, or and talk to them about what they want. And the person, it's so interesting because sometimes people are quite ill and they can't communicate, very easily. But if someone can convey that they want someone to help them, or to be able to dispose of your assets, you are required to have a sufficient knowledge of what the assets are, and kind of who your main people are, like who you want, and maybe who your family are, especially if you don't want them. You need to kind of know who people are and convey that. But the bar is quite low, for that. And then for other documents, like a power of attorney, you have to show. So a lot of times I'm looking at a lot of the same cognitive abilities that a doctor might, like, are they being really repetitive? How's their memory? If I'm uncertain, I may ask them to get an exam, a mental exam, just to bolster the documents, to strengthen them. But in the law, it's kind of interesting because having issues with the different areas of mental processing is just part of it. So you can have those, but if those issues that you're having don't interfere with who you want to name, if kind of what you want to do makes sense, it's a green light for the lawyer. We can go ahead and do the estate planning. If the cognitive issues cause the person to do something that they wouldn't ordinarily want to do, then it's not considered legal.
So I just want to repeat that back to make sure you
Yeah.
understand. So basically, if someone is constantly calling people by the wrong names, that could impact their legal capacity to be accurately creating the documents. Whereas if someone just forgets something pretty benign, not really related to this, they forget where your office is located consistently, that's not necessarily related to this.
Yeah, I would even say, you know, if you can identify, a common issue I have, maybe I have someone that's kind of lost track of numbers. Yeah, you know, and we'll talk about, okay, who are your important people? And you think about dividing a pie, you know, kind of the percentages of who gets what. And maybe someone can say this person is the most important, but then I want to remember this other person. But if you try to assign a number to it, they have a trouble, you know, doing that, like the percentage or the number. And so sometimes you can work within that, and if they are able to communicate, if they're able to make it pretty clear what they want, even if maybe the specific words are incorrect, like maybe they keep calling a child the wrong name. You know, if you can kind of figure out what it is. But it's all of that. I know when I'm working with clients, I'm looking for things like that, and I'm always looking at, okay, if I wanted to try to argue that like mom or my friend, you know, that maybe wrote me out of their document or put me in, you know, maybe that they didn't have capacity. I look at, you know, I might look for things like that. And so sometimes you might even have more than one attorney, or you might have, you know, as a doctor give an opinion and things like that. You know, especially if there's a lot at stake.
Yeah.
For keeping. Unfortunately, contests of documents it's a huge industry.
Yeah.
You know, legal contests. So you want to be real careful.
Absolutely. Do we have a question on the computer in the back? Okay. Anything anyone up front wanted to add to that? All right, question in the back and on the computer, and then we'll go over here. No. There you go.
Can changes be made on a trust without a notary, just writing on the trust and signing next to changes?
I'm going to be obnoxious. It's a lawyerly, it depends. Kind of a lawyerly answer. In California, no. You know, some states might be. Well, in California, technically, you don't need a notary for a trust, but you do need to have having just handwritten changes that are initialed. That's not valid unless the words alone manage to qualify as a holographic document. And often they aren't, you know, if you're just crossing out a name and initialing it. So it is, I have many people ask me that, or they've done that, you know, trying to update their documents. And a lot of the time that's just not going to work, you know, under the law in California.
Thank you so much. And we have a question over here.
Can one of the heirs, like a child, be an executor? The beneficiary be the executor?
Yes. Yes.
Absolutely. I think anyone can be an executor.
Oh, yes. You can really name anyone to be your executor. I'm just trying to think. You know, at naming somebody, there are some. There's kind of a body of law and some protections in place when you have someone assisting you. So sometimes there is a whole area of law when you have a caregiver or someone that you met because they were providing care to you, or some other assistance when you then try to add them to your documents. and there could be a presumption that that is invalid, because of the fear maybe that the person's unduly influencing you. But working and just simply having an attorney review it can usually help that situation. And those rules don't apply if the person is a family member or someone related by marriage or someone that you have a pre-existing relationship with. Because it's so common that the person that might be the one you trust to help you is also your loved one, that you want to leave property to. But yeah, that is a good question.
And then we have one last question in the back.
So
It's on.
Okay.
my parents have an irrevocable trust, and my mom left instructions on how to do certain things with personal property like jewelry and her car. And then she got Alzheimer's, and my dad did contrary to what her trust said. Is there something I could do about that? I did talk to him, and that was not successful.
It's very painful because
Can you speak into the
Oh yeah. I'm sorry that that's very painful. And the tools for dealing with that, it's really like coming at it with the hammer. There aren't really fine tools in place, because if somebody goes through, what you can do is sue them for the value. And if it's tangible property, often, the sentimental or, the value isn't really measured by the value of the item. And then it's also really difficult within a family to be in a position to sue somebody, that's a family member. And that can be really common where people, grief can really bring up a lot. Like people, anyway, that's just very painful. That sort of thing. I'm sorry. Yeah.
We had more computer questions.
Yes. Is it common to have planning sessions with attorneys videotaped?
Oh, I go to my own continuing education, and a lot of the litigators say, you know what, you're just making Exhibit A, for the lawsuit. If you have the video, a lot of, if there's a capacity question, it's. I know sometimes people do. Often, if you're at a point where you're wanting to videotape it, it's probably because there's a big question about how, what sort of shape the person's in and what their intentions are. And I think it's really good to sure, maybe videotape it, but get additional support for that plan over time, like having them get a certificate of independent review. If the person can go talk about the same plan with a couple of different attorneys over time, that's very supportive. And if if you can have the reasoning for the plan, I spend a lot of time talking to my clients and take a lot of notes about why they want to do something, just so I have that. The other thing is, sometimes if someone's willing to go get a psychiatric examination and get a doctor to sign off and do some things over time, it really shows that is what they want. So it can be a good way. So I would say if you're doing that, don't just rely on that.
And then we had one more there. We have one in the front, and then we'll be done.
So when hypothetically you
Yes.
have older person who's always been very independent and able to do everything and is losing that ability and needs help, but then maybe they are succumbing to some of these situations you mentioned where they're being not critical enough,
Yes.
to discern when something's a scam, for example.
Yes.
How as like a person who's helping them as like their power of attorney, how do they help protect the person without taking away their independence? How do you walk that line?
You know, it can be difficult, and I know a lot of times when I'm talking to someone who's looking at that sort of transition, I'll often start with them, you know, you can name the person to act as a co with you. Yeah, you know, like you're the principal under the power of attorney, they're the agent. You know, you can still access all your accounts. You know, so maybe you start off that way, and as the person's comfortable, they might withdraw from managing things. And I think for the person who's the helper, it's really important to let the person kind of make their mistakes, you know, and don't catastrophize it, you know, because a lot of times it's really, people can be really ashamed. You know, I had a client give a $25,000 gift to a fellow at the gas station, you know, and his son found out about it. And he was really mortified when he kind of sat in. So it's removing somebody entirely. You know, sometimes someone, if they have a trust, they might be willing to resign. A conservatorship is a way to, you know, you really stop someone from being able to access their assets. And that can be very traumatic for someone. Yeah, you know, that they're dependent on the person, you know, the conservator for everything. You know, so sometimes I think it's, you know, you want to help them and try to, but keep some autonomy. That's worth a lot too. Yeah, you know, the autonomy is worth a lot.
And some solutions I've seen have been maybe some accounts transfer over and not all accounts. Or if you can't have a credit card, maybe they can have a debit card. Things like that can get you in the middle.
Amazing. Yeah. You know, that's actually a really good way to do it. Yeah, you know, sometimes bankers and financial advisors now are really under a new duty to assist, and a lot of times they're really happy to play along. And if you have the two people, they'll call the, you know, the co-trustee. You know, they'll say, okay, you know, the person's wanting to do this. What do you think? I'll stall them. You talk to them, and you know, you can have that sort of a protection. And then giving the person their own money or their own credit card where it's a little more contained is fantastic.
Yeah, credit card with $500 limit instead of a $50,000 limit.
Exactly. So
Awesome.
yeah, that's really good idea.
And then we'll take the question in the front.
I gave my mother some advice about who to distribute her jewelry to. And I said, don't decide or don't put it in. Let me rephrase that. Don't let the person decide after she dies. You do it now, before you die. And she took my advice and she put the names of the children in the family on the jewelry. Then she decided, no, I think I'll give them now before I die. And she did. She gave away her jewelry. But give them the personal property before you die. This way, you know who's going to get it for sure. And I think you avoid inheritance tax.
Well, you know, that is such a lovely idea. And I've had some of my clients kind of come up with that solution and they really enjoy it. Yeah, you know, they enjoy explaining what the item is and why they want to give it to the particular person, you know, and that's lovely. For transferring assets before or after death, you know, if you're trying to kind of avoid taxes, they get you. Yeah, you know, the value of the assets, they have gift and estate taxes. So they'll kind of get you one way or the other, depending on the timing you try to do it. And if it's too close to death, they might even sweep it back into the value of your estate. So, you know, fortunately, the amount before estate taxes are imposed is, it's I think it's about 13 million plus this year. Next year, it's going to go down to around, I think with inflation, it's going to be 6 or 7 million. I see the two different numbers. That's going to happen next year per person. Yeah, you know, that you can, I mean, each individual may leave that much before there are transfer taxes. So,
well, it wasn't to avoid inheritance tax.
Oh, yeah.
I mean, she's still alive.
Yes.
And this was years ago.
Yeah.
that I advised her to do that. So
Well-
it's not close to death at all.
Oh yeah.
Yeah.
Well, I think it's lovely, and that's such a good idea, and it can be something to do over time too. For holidays.
Mm-hmm.
Yeah,
That's what
really
happened during
special.
the holidays. She distributed the jewelry to us.
Yeah, and you're allowed to give a certain amount each year to individuals before you have to report it. And this year it's 19,000. So even if you're giving a really nice piece of jewelry, unless it's like $1 million engagement, something really wildly expensive, usually that covers most people's items, that they give.
Thank you so much. Thank you so much. We will go ahead and have everyone return again later, but we'll move on to our housing section now.